The prosecution responds to the Vallow's motion for a new trial. More arguing about cameras in the courtroom in the Kohberger matter. Former President Trump is indicted and the indictment is unsealed, and he's got some problems. Casey White's been sentenced. Harmony Montgomery's father's been convicted. And then finally, our dumb criminal of the day. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment and hit that little bell. And remember, you can listen to us anytime on any of your favorite podcasting apps. Now, you also know what we have to do. That's support the people that support us. Go to crimetalksearch.com and sign up for that background subscription service. Take a look at this unsolicited recommendation from a subscriber who said, I was a little skeptical of what Scott was talking about. I signed up and it worked perfectly. Disclosed a criminal history of somebody that they were going to bring on to do some independent work for them. And, well, they checked out. It worked. I'm telling you, it works. Go to crimetalksearch.com. Sign up for that background subscription service today. You're going to get all the information you need to know about somebody. Are they a good person? All right. Past performance is indicative of future results. If they've got a history, could mean problems. No history, maybe it means they're good. But at least check them out. Get that peace of mind. crimetalksearch.com. All right. We have a big show for you today. A lot is going on, so let's go ahead and open the record for June 9th of 2023. All right, first, the prosecution responds in regards to the motion for a new trial that was filed by the defense in the Vallow matter. It is a lengthy response that the prosecution has filed, and I'm going to cut to the main points of it. As you may recall, the prosecution convicted Vallow, and the defense moved for a new trial. Several grounds were that the prosecution was able to amend the indictment at the very last minute, literally 30 minutes before they rested their case, that the judge gave some incorrect jury instructions, and then also finally that there was alleged juror misconduct. Needless to say, the prosecution thinks those arguments are wrong, frivolous, and that the court should promptly deny the motions. So let's see what they have to say. First, just for background, on May 25th, the defendant filed a motion for a new trial, and the hearing has been set for June 15th of 2023. So that's coming up next week. The prosecution argues that neither the statute nor the rule prohibit the grant of a new trial on grounds not argued by the defendant, so long as the defendant has requested a new trial and the grounds relied upon by the court is one of those specified in the statute. Now, the statute that they're referring to and the rule is the Idaho Criminal Rule 34 and Section 19-2604, which states when a verdict has been rendered against the defendant, the court may, upon his application, grant a new trial in the following cases. First, when the trial has been had in the absence, if the indictment is for a felony. They basically tried somebody in absentia. They don't do that very often. They just issue a warrant for somebody's arrest. When the jury has received any evidence out of others that results from a view of the premises, when the jury has separated without leave of the court after retiring to deliberate upon their verdict, or been guilty of any misconduct by which a fair and due consideration of the case has been prevented, when the verdict has been decided by lot or by any means other than a fair expression of opinion on the part of all jurors, basically not a unanimous jury, and when the court has misdirected the jury in a matter of law or has erred in the decision of any question of law arising during the course of the trial, and when the verdict is contrary to law or evidence, and when new evidence is discovered material to the defendant that which could not be reasonably discovered with diligence and produced at the trial. The prosecution wants to argue that, hey, let's take a look at these and see how they don't apply. The first was obviously Vallow was present for a trial. Doesn't apply. The defendant asserts the jury considered evidence not introduced at trial. However, there's nothing to support the defendant's assertion. The jurors remained through the deliberations and verdict. Nothing has been alleged, nor is there any support that the verdict was decided by a lot to the contrary. And each juror answered yes when the verdict was read and they were polled. And the defendant then contends the court misdirected the jury in a matter of law or has erred in the decision of any question of law arising out of the course of the trial. However, the state opposes this assertion. And then the defendant contends that the verdict is contrary to law or evidence, but there's nothing to support that contention. There's no allegation or assertion of any new evidence, and the defendant focuses their argument on a new trial, and the state obviously disagrees. They're arguing sections 2, 5, and 6. So the prosecution then states that higher courts in Idaho have clearly established that any variance regarding the named co-conspirators or number of co-conspirators is not a material variance, since the burden with the conspiracy is to prove only that the defendant conspired with at least one other person, not to prove an agreement between all named conspirators or even the identity of the other co-conspirators. Remember, they said, hey, you charged all these people in this conspiracy, and then you got the trial and basically said it was just a conspiracy between Alex Cox and Lori Vallow, when in your indictment you said it was up to 5 people. Shouldn't have done that. Prosecutor says, hey, we only have to show there's a conspiracy between 2 or more people. That's all they had to do. And the prosecution says, hey, you were on proper notice of any of the charges against you. That's kind of the standard argument prosecutors make. You were on notice. You're on notice. Anyway, the court, the rules state that the court may permit amendment of a complaint, an information or indictment at the time before the prosecution rests if no additional or different offense is charged and if substantial rights of the defendant are not prejudiced, right? Read, what's the significance of that there, ladies and gentlemen? The complaint or information at any time can be amended if no additional or different offense is charged. Now, of all of the arguments that the defense made, I still think this is the strongest. The judge let them change that. But when you're changing a different subsection of the statute, how is that not another offense? It is. So anyway, the prosecutor says, hey, we did an indictment, but the information can be amended without leave of the court, which is just simply permission, at any time before the defendant pleads. Well, obviously that didn't take place. At any time thereafter, in the discretion of the court, where it can be done without prejudice to the substantial rights of the defendant. Okay, you're in trial. And listen, I don't think, I'd be surprised if Judge Boyce grants the defense motion in any way. This is probably the best argument. But the judge already granted it, so he's going to make it look like he's wrong. Now, the only way the judge could do this is, you know what? Maybe I was wrong. I shouldn't have done it. I was upset. The prosecution, this was not a small clerical error. It's a different statute. And the fact that you guys didn't figure this out in 2 years since you indicted them, that's on you. Too bad, so sad. I'm going to grant a new trial, and guess what? We'll go do it with Chad Daybell on April 1st. I don't think the judge will ultimately do that, but that would be the best case scenario for the defense. I don't think it's going to happen. And so obviously the defense says that the amendment is to count 1, 3, and 7 of the indictment, and counts 3 charges the defendant with conspiracy to commit murder in the first degree. Count 7 charges the defendant with grand theft. In count 7 of the indictment, while the defendant was charged with grand theft pursuant to the Idaho Code, the indictment included the language by deceit and with intent to deprive, which is reflective of the language contained in the statute. The charge of grand theft is the same underlying grand theft referenced by the conspiracy charge in count 1. And once again, the prosecution argues the defense was on notice. But now, as you may recall, throughout these proceedings, the defense kept saying, this doesn't make sense. What statute and what subsection are you applying it on? And the prosecution kept saying, you've received a discovery, you have the indictment, that's what we're relying upon. And then somebody, some genius, right before they closed said, oh my gosh, we didn't charge the right statute, the wrong subsection. Oh my goodness. That's why I think it's the best argument for the defense. Makes the prosecution look not so great. Makes them look, frankly, a little bit incompetent, even though they got a conviction, which lots of things were going in there. But that's the gist of their argument. And the state ultimately concedes that, hey, while the indictment in this case wasn't amended until just before the close of the state's case, the defendant was on notice of the grand theft, was being prosecuted on a theory of theft by deception, and that the grand theft was the basis of the conspiracy to commit first-degree murder and grand theft. Hey, prosecutors, and here's going to be the simple thing to see if they're being disingenuous. In Chad Daybell's case, are they going to amend his indictment, or are they going to do the same thing all over again? And if they move to amend it, it shows that they got it wrong in Lori Vallow's case. Just something to think about. And next, the prosecution says the instructions weren't confusing, and the jurors considered the evidence, and there's no basis whatsoever that there was juror misconduct. Frankly, I think that's the least best argument that the defense has in this particular case. And like I said, I think the court will more than likely deny all of those motions. But we wanted to bring you the government's argument so you could hear it for yourself and see if it makes sense. Let me know if it makes sense. Next on the docket, Bryan Kohberger. He's back in court today. Now, if you listened to our live the other night, we had a conversation about Kohberger. And listen, the defense should use the media to help their client any way they can. And I said, by the way, Kohberger defense attorneys, why don't you put your guy in some civilian clothes and not have him dress out in jailhouse garb every time he comes to court? I said, look what John Pryor does in the Chad Daybell case. He always shows up with his little white shirt and his tie on. Makes him look like a human being and not somebody in custody. So what happened today? I mean, do I dare say that the defense in the Kohberger matter has been listening to CrimeTalk? Touch your nose, attorneys, if you've been listening. We know you have. Anyway, so Bryan Kohberger showed up in court today. There was a hearing regarding the gag order. As you may recall, the prosecution and the defense wanted a gag order. The court kind of rubber stamped it, but it was pretty broad. And it said nobody, not the attorneys, anyone that works with the attorneys, the police, anyone that works with the agencies, any governmental agencies whatsoever cannot talk about the case. Well, you can have a gag order. You can limit the professionals in there, but it can't go so far that literally suppresses the First Amendment. We brought you the arguments the other day, the last 2 days. Very good arguments, frankly, on both sides. Both the prosecution and the defense want the gag order to remain because they think it's going to affect both the state and the defense receiving a fair trial. The news media says we want to be able to televise it. We're just delivering the facts. And if those facts are what they are, the people should have a right to know, and we shouldn't have to go wait until trial to sit in the courtroom and observe what's taking place. Makes sense to me. So attorneys for obviously the prosecution and the defense were there, and then there were attorneys from the media as well as the Gonsalves family who wants the order lifted because they want to be able to talk about the case in the media. The court made no decisions, which means he's got a tough decision to make. How do I weigh the interests of the public to know, the right to the victim's family to talk about their loved ones, and if it brings out the information in the case, as well as to protect Mr. Kohberger's right to a fair trial? Here's the thing. If it's factual, it shouldn't matter if it's released or not. If it's untruthful, then people need to be sanctioned for that in a particular way, in some way. The court can tailor something, but we'll have to wait and see. So as soon as the order comes out, we'll let you know. But at least we know that the defense attorneys must be listening to CrimeTalk because at least they put their client in a suit and tie today. And oh my gosh, he doesn't look so weird and creepy or scary, does he now? See, defense, you can use the media to your advantage for your client. Quit being afraid of the media. Embrace it. It's like a bad fact. You have to embrace it to help your client. Let them know why your client is being wrongfully accused. I'm not saying he is, but that's your theory. Let them know, let the world know why he's being wrongfully accused. And if you'd like to talk about it, feel free to come here on Crime Talk. All right, ladies and gentlemen, next on the docket, former President Trump has been indicted. We've got the indictment. It has been unsealed. It is charged out of the Southern District of Florida, and it alleges several things that I think are worth going over. First, it says that obviously Donald Trump was the 45th president of the United States, Over his presidency, he gathered newspapers, press clippings, notes, other official documents, and they were kept at the White House and ultimately put in cardboard boxes. And also they found in those boxes were hundreds of classified documents, and that those boxes included information regarding defense and weapons capabilities of both the United States and foreign countries, nuclear programs, potential vulnerabilities of the United States and its allies to military attack, and plan for possible retaliation in response to a foreign attack. And that an unauthorized disclosure of these classified documents could put at risk a national security of the United States. And then on 12 p.m. on January 20th, Mr. Trump ceased to be president, and he departed, went to Mar-a-Lago. And then in 2021, Trump showed classified documents to others as follows. In July of 2021, at the Trump National Golf Club in Bedminster, New Jersey, during an audio recording meeting with a writer, a publisher, and two of his staff, none of whom possessed a security clearance, Trump showed and described a plan of attack that Trump said was prepared for him by the Department of Defense and a senior military official. Trump told the individuals that the plan was highly confidential and secret. Trump also said, as president, I could have classified it, and now I can't, but this is still a secret. Then in August of 2021, at the Bedminster Club, Trump showed a representative of his political action committee who did not possess a security clearance a classified map related to a military operation and told the representative that he should not be showing it to the representative and the representative should not get too close. In March of 2022, the FBI opened up a criminal investigation regarding documents at Mar-a-Lago. They alleged that Trump then endeavored to obstruct the FBI and grand jury investigation and conceal his continued retention of classified documents by, among other things, suggesting that his attorney falsely represented to the FBI and grand jury that Trump did not have any documents called for the grand jury, directing the defendant, Waltine Nauta, N-A-U-T-A, to move boxes of documents to conceal them from Trump's attorneys, the FBI and the grand jury, suggesting that his attorney hide or destroy documents called for the grand jury subpoena, providing to the FBI a grand jury just some of the documents called for by the grand jury subpoena while claiming he was fully cooperative, and causing a certification to be submitted to the FBI and grand jury falsely representing that all documents called for by the grand jury subpoena had been produced, while knowing that, in fact, not all such documents had been produced. As a result, in regards to the retention of the classified documents after his presidency and refusal to turn them over, hundreds of classified documents were not recovered by the United States until 2022. That was when the FBI on January 17th executed a search warrant and took the documents. Now, Trump's co-conspirator. Now, what are the ultimate things we talk about here on Crime Talk, right? Go check out the 12 undeniable truths of life from a criminal defense attorney. Well, we know there's two types of people in the world, those that are humble and those that are about to be. And I've always said it, it's always the defendant's own words that come back and bite them in the end. And that may be the case with Donald Trump. Now, what have we also said? That the threat of imminent incarceration tends to break the bonds of loyalty. That's why if you're going to commit a crime, you should probably only do it by yourself, because someone then could always roll on you and get a better deal. And then the question becomes, is this defendant Nauta, N-A-U-T-A, who was a member of the United States Navy stationed as a valet in the White House during Mr. Trump's presidency, and then in August of 2021, Nauta became an executive assistant in the office of Donald J. Trump and served as Trump's personal aide or body man. Nauta reported to Trump, worked closely with Trump, and traveled with Trump. They then go talk about the club. They talk some more about the confidential information. What is, in fact, the confidential information? The documents that were prepared for various agencies and how they basically got there. Documents that belong to the CIA, the Department of Defense, National Security Agency, the National Geospatial Intelligence Agency, the National Reconnaissance Office, the Department of Energy, the Department of State, and Bureau of Intelligence and Research. Then it says Trump made public statements on classified information. As a candidate for president of the United States, Trump made the following public statements, among others, about classified material. On August 18, 26, Trump stated, "In my administration, I'm going to force all laws concerning the protection of classified information. No one will be above the law." He stated, "We also need to fight the battle by collecting intelligence and then protecting our classified secrets. We can have someone in the Oval Office who doesn't understand the meaning of the word confidential or classified." See what I'm saying about your own words coming back to bite you? Trump also stated in September of 2016, "One of the first things we must do is enforce all classification rules and to enforce all laws relating to the handling of classified information." Trump said we also need to be able to be the best protection of classified information. And service members here in North Carolina have risked their lives to acquire classified intelligence to protect our country. And it goes on to additional information, the retention of classified documents. Then on April of 2021, an employee of the office of Donald Trump texted another employee to ask whether Trump's boxes could be moved out of the business center to make room for staff to use in an office. Trump employee number 2 replied, "Whoa, okay, so POTUS specifically asked Walt for those boxes to be in the business center because they are his papers." Later that day, Trump employee number 1 and Trump employee number 2 exchanged the following texts. Employee number 2, "We can definitely make it work if we move his papers into the lake room." Employee number 1, "There's still little room in the shower where his other stuff is. It is only his papers he cares about. There's some other stuff in there that are not papers. Could that go to storage, or does he want everything on the property?" Trump employee number 2, "Yes, everything that's not the beautiful mind paper boxes can definitely go to storage. Want to make a look at a space and start moving tomorrow a.m." Then they show some pictures related to the search warrant of the Mar-a-Lago. Then they discuss the disclosure, which we already talked about, that these are documents prepared by the military officials. And it goes on. And then we finally get to the false certification to the FBI and to the grand jury. You know, it's not the act, it's the cover-up that will get you as well. And they say ultimately in Trump's office they had 27 documents, 6 top secret, 8 secret, 3 confidential. And in a storage room they found 75 documents, 11 top secret, 36 secret, and confidential. Counts 1 through 31. Count 1 is a top secret document concerning the White House intelligence briefing related to foreign countries. Count 2, documents dated May of 2018 concerning the White House intelligence briefing related to various foreign countries. Count 3, undated document concerning military capabilities of a foreign country. Count 4, documents dated March 6, 2019 concerning the White House intelligence briefing related to foreign countries, including military activities and planning. Document dated in count 5, June 20th, concerning nuclear capabilities of foreign country. Count 6, documents dated June 4th concerning the White House intelligence briefing of foreign countries. Count 7, October 21st, 18, concerning communications with a leader of a foreign country. Count 8, documents dated October 4th concerning military capabilities of a foreign country. Count 9, undated documents concerning military attacks on a foreign country. Count 10, documents dated November 2017 concerning military capabilities of foreign country. Count 11, undated documents concerning military contingency planning of the United States. Count 12, pages of undated documents concerning projected regional military capabilities of foreign countries. Count 13, undated documents concerning military capabilities of a foreign country in the United States. Count 14, documents dated January 2020 concerning military options of a foreign country and potential effects of the United States. January 20, 2021, documents dated February 20th concerning policies in a foreign country. Count 16, documents dated December 2019 concerning foreign country support of terrorist acts against the United States. Count 17, document dated January 2020 concerning military capabilities of a foreign country. January 18th, documents dated March 20th concerning military operations against the United States. Count 19, documents concerning nuclear weaponry of the United States. Count 20, documents concerning timeline details of attacks in a foreign country. Count 21, undated documents concerning military capabilities of a foreign country, and documents dated August 19th concerning the regional military activity of a foreign country. Count 23, documents dated August 3rd concerning the White House intelligence briefing related to foreign countries. Count 24, undated documents concerning military activities of a foreign country. Count 25, documents dated October 24th concerning military activities of a foreign country. Count 26, documents dated November 7th concerning the military activity of a foreign country. 27, documents dated November 2019 concerning military activity of a foreign country. Count 28, documents dated October 18th, 2019 concerning White House intelligence briefing related to various foreign countries. Count 29, documents dated October 2019 concerning military capabilities of a foreign country. Count 30, documents dated October 15th concerning military activity in a foreign country. And count 31, documents dated February 27th concerning military activities of a foreign country. And these are either top secrets type of documents. Count 32, conspiracy to obstruct justice, alleges that between May 2022 through in or around August 2022 in Palm Beach, in the Southern District of Florida and elsewhere, the defendants Donald J. Trump and Waltine Nata did knowingly combine, conspire, confederate, and agree with each other and with others known and unknown to the grand jury to engage in misleading conduct towards another person and corruptly persuade another person to withhold records, documents, and other objects from the official proceedings in violation of the code. The purpose of the conspiracy was for Trump to keep classified documents he had taken with him from the White House and to hide and conceal them from a federal grand jury. The manner of the conspiracy says that the manner and means by which the defendant sought to accomplish the objects and purpose of the conspiracy included, among other things, suggesting that Trump Attorney 1 falsely represent to the FBI and grand jury that Trump did not have documents called for by May 11th and moving boxes of documents to conceal them from Trump Attorney 1 from the FBI into the grand jury, suggesting that Trump Attorney 1 hide or destroy documents called for by the May 11th subpoena, providing to the FBI and grand jury some of the documents called for in the May 11th subpoena, while Trump claimed he was cooperating fully, and causing a false certification to be submitted to the FBI and grand jury, representing that all documents and classifications markings had been produced, making false and misleading statements. Count 33, withholding documents. Count 34, corruptly concealing documents. Count 35, concealing a document in a federal investigation. Count 36, a scheme to conceal. Count 37, false statements and representations. Just so we're clear, the allegations that they say were false was that attorney number 3, a diligent search was conducted of the boxes that were moved from the White House to Florida. The search was conducted after receipt of the subpoena in order to locate any and all documents, and any and all responsive documents accompanied this certification. The allegation is that the statements and representations set forth above were false, as Trump knew because Trump had directed that the boxes be moved from the storage room. Count 38, false statements and representations. So there you have it, ladies and gentlemen, the indictment against former President Donald J. Trump. Now, obviously, a lot of people are going to be saying Donald Trump deserves everything he gets. They believe that he is a horrible human being. Other people are going to say that Donald Trump is being wrongfully prosecuted by the Department of Justice, and this is all political. Frankly, we're going to have to wait and see. Now, here's what a criminal defense attorney would tell any client, even if it was the former president of the United States. Sir, you've got 37 counts. Your attorneys have obviously testified against you. A lot of them have withdrawn because of some of these representations. And my guess is that this Waltine Nata may be a defendant. It's probably going to be a witness against you real soon. And we can go in there with the liar, liar, pants on fire defense all we want, but the reality of it is something of these 37 counts are going to stick. Doesn't look good. Not a good day for the defendant, Donald J. Trump, former president. Not a good day for America either. But like I said, 12 undeniable rules of a criminal defense attorney. Check out the video. Rule number 1, 2 types of people, those that are humble and those that are about to be. Just saying. You think if Donald Trump had gone away quietly, there'd be anything about this? Probably not. We're going to have to wait and see. and the threat of imminent incarceration tends to break the bonds of loyalty. My guess is this Mr. Nata, Miss Waltine, or Mr. Waltine Nata is going to be a defendant against the former president. I should say he's going to be a witness against the former president. And y'all wonder why you have no trust and faith in politicians or the government. None whatsoever. Because even though there appears to be probable cause, a grand jury made up of regular citizens in the Southern District of Florida has said probable cause exists. I'm sure some of those people even voted for him. And now they voted to indict him. Just saying, ladies and gentlemen, nobody's above the law. Is a political witch hunt soon to be determined. Next on the docket, Casey White has been sentenced. Casey White has been sentenced to life after he broke out of jail with the help of his prison guard lover and led police on a 2-week-long manhunt. Now, White appeared in the courthouse in Alabama yesterday, charged with first-degree escape after breaking out of the Lauderdale County Detention Center back in April of 2022. The convicted felon was given life in prison, the maximum sentence possible for the offense, after a plea deal saw a murder charge over the death of his lover, Vicky White, dropped. He stated, quote, "I feel like the most hated man in the world. I love Vicky, and I wouldn't drag her name through the mud for anyone in this courtroom," he said. "We just wanted a new life together because she knew the truth. I can handle the truth because I know who I am. I chose this road. It cost me my life and my freedom. I apologize to her family because she said that's the only thing she regretted leaving was her family." Now, Vicky was the assistant director of the corrections of the Lauderdale County Detention Center at the time and helped White hide from authorities for more than 2 weeks. He deserves life. I guess the only thing is maybe it's too bad. I guess it would have been a better love story, so to speak, if they both died instead of just the former police officer who helped him escape and gave up everything for this guy. Really? You couldn't have found somebody that wasn't in prison for the rest of his life? I just never will understand that. All right, the dad of Harmony Montgomery, convicted. That's right. The father of the murdered 5-year-old Harmony Montgomery, who vanished back in 2019 and whose body has still not been found, was convicted on unrelated gun charges. Adam Montgomery was found guilty of 6 weapons charges, 2 counts of being an armed career criminal, receiving stolen property, and theft by an unauthorized taking. The most serious charge being an armed criminal, which carries the maximum sentence of 10 years in prison. Now, back in January, Adam was indicted and separately charged for the alleged murder of his daughter Harmony, who disappeared back in 2019, but the authorities did not know that she was missing until November of 2021. He's also facing charges of abuse of a corpse, falsifying evidence, and witness tampering. He's scheduled to have those trials in November. Now, you'd say, why would he go to trial on this? It was probably a GORT trial. GORT stands for guilty or trial. Get it? G and then or, trial. Plead guilty to everything or we'll go to trial. Defense attorney probably said, we'll see you in trial. We'll try to create some appellate error and maybe you're going to get the conviction, but we're going to make you crawl over glass to get there. And then finally, our dumb criminal of the day, well, is a police officer. A San Fernando police officer by the name of Jeffrey King has been charged with 1 felony count of second-degree robbery and extortion and 1 misdemeanor count of petty theft. The warrant issued in June when, back on June 21st of 2022, King responded to a home in San Fernando to a report of a domestic violence, where he arrested a suspect. And according to the district attorney's office, the suspect was released from jail on June 23rd, and he reported that he was missing money that he had in his pocket during the arrest. The district attorney's office alleges that King took cell phones and cash from the suspect's pockets during his arrest. He reportedly gave the cell phone to the supervisor, but he never turned over cash into evidence, nor did he give the money back to the suspect. So the district attorney said they did not disclose how much money was stolen during the domestic violence incident. However, King's arraignment will be scheduled at a later date. The district attorney's office said law enforcement officers take an oath to uphold the law, not to break it. I agree. When you're a police officer in a position of authority, a leader, you have to do it better and cleaner than the next guy. Kind of like even if you were the president, you got to do it better and cleaner and be squeaky clean. That's all we have for you today, ladies and gentlemen. It's been a busy week. Hope you have a wonderful weekend, and we'll see you next week.